At about 8 o'clock at night, and this is probably one of the last things I'll be doing as Vice President of the Council until something unexpected happens. Well, thank you for coming. This is the second annual session that we've had with all the boards and commissions and elected officials in town and officials from the school department and from town hall. And many of us volunteer, and those of us who are elected, whopping, $500 a year, which are basically volunteers, to do our jobs. Unlike most cities and towns where they get paid lots of money to be on boards and commissions and have benefits, we get nothing other than the honor of serving, which is why all of us do it. And because we're doing that, we want to make sure that we're not running afoul of anything legally, which is why we have two very, very good speakers tonight, which I'll introduce in a moment. But first, I'd like to introduce June Speakman, who is the President of the Town Council, and Patrick Gaida, who is the Chair of the School Committee, for brief comments to welcome everyone.
Good evening, everyone. Thank you so much for coming. We did one of these a little bit ago, and I said then what I'm going to say now, which is that the government of the town of Barrington could not run without all of you volunteers. We are blessed in this community with large numbers of committed, competent, smart, hardworking volunteers who go to evening meetings, usually more than one a month, even though that's a meeting when we honored his service. He has been sort of my guiding light as a council member, and I'll miss him, although I know his phone number at his desk. Peabody and I intend to use it frequently, and again, he's one of those folks who, even though he does get paid a large sum of $500 a year, I think that counts as volunteer service, has been given remarkably to the town, and thank him for that. So thanks, Jeff. I want to thank Jonathan, who's doing the video back there. Thank you very much. His services are provided by him and the school department, so thank you for that. I want to thank Carol, Marianne, and Mary for helping put this together tonight, and in particular Cindy Coyne, this is her baby, this is her idea, and the other council members don't have to do anything except say, it's a great idea, run with it, and I'm grateful for that, so thank you very much to you for and I want to thank Mike Field from the AG's office and Andy Tice from our solicitor's office for whatever it is they're going to do, we shall see. So again, thank you all for coming, and to you.
Thank you. The school committee is very pleased to be participating in this event. There are a number of opportunities throughout the year at which we can get opportunity for professional development in the area of open government. Michael has often hosted an annual conference at Roger Williams Law School. It usually happens at the very end of the summer. Isn't that about right? Right, about right. And so we can't take this seriously enough, because this is really important stuff, and I'm glad to see the audience here. On behalf of the school committee, we have with us tonight Bob Shea, Kate Brody, Mike Masori, our superintendent, and Ron Terrell is also here. And so I'm very pleased and would like to not delay the proceedings any further, but just thank you for all coming. And if there's anything that you would like to address with the school committee, we again encourage you to do so. We look forward to engaging with the community. Thank you.
In my copy of the Rhode Island Dictionary, the definition of Michael Field is open meetings compliance and open records compliance, and he needs no other introduction than that. He has been doing this job for many years at the Attorney General's office, and everyone in the state looks to him to decide these issues when they're raised by people throughout the state. So Mike, the microphone's yours.
First, I'd like to thank everybody that has already been mentioned, but I certainly want to thank them all again. And I noted Jeff's definition of my name, but I assure you there are a lot of people who have different definitions of my name. Before I start, I was actually they hooked up the website from the AG's office, and I see it cycling through, and we're about to announce, and I guess we just announced it since it's on the website and it's in front of everybody here, that on January 8th, the Attorney General is going to be hosting what you'll see in a second, I think, is we've called the Open Government Summit 101. And it's going to be, it's right here actually, it's going to be at CCRI in Lincoln, and there's an agenda that's attached. All this information is already on our website at riag.ri.gov, and it's really aimed at newly elected members. Anybody's obviously invited to attend, but it's really aimed at newly elected, newly appointed members, an introduction to the open government laws. Tonight, we're going to go through pretty quickly on, there have been amendments to the Access to Public Records Act during the last legislative session. That's really what I'm going to focus on tonight. We're going to go through that pretty quickly. But whatever questions you have about public record laws, about open meeting laws, I'm certainly here to answer those questions, and I'll try to address those. So let me get to this. You've got a couple handouts. You've got a copy of the Access to Public Records Act, which has some strike-throughs. That's the amended version. So you see exactly what the General Assembly added and subtracted. And you may have some other documents also, but I know at least one of them is this chart that we did. And I'm not going to go exactly in order of this chart, but this chart is really I guess a cheat sheet or an easy document to look at to see what the Access to Public Records Act was prior to its effective date, September 1st, 2012, which is on the left-hand side, and what the Access to Public Records Act, at least the amendments or the changes are on the right-hand side.
Does anyone need a handout? Let me bring a few of them in. I saw a couple of empty labs. Hey, sit down, Margaret. Listen, I'll go get the handout.
And these handouts, by the way, are also on our website, so there are copies here certainly, but our website has all this information and more. So let me go through and just highlight what the changes were this past year. There were both substantive and procedural changes to the Access to Public Records Act. The substantive, if you look at the chart, it's on that first page. This is one of the more significant changes. It's one of the two substantive changes, but it's a significant change. What the Access to Public Records Act used to say was that all documents that were identifiable to an individual were exempt. If you asked for the superintendent's contract, that was exempt because it was a document identifiable to the superintendent, identifiable to an individual person. That exemption has been significantly narrowed. Now the exemption says that records that are identifiable are exempt, but only if disclosure, and you can see it up here on the PowerPoint, only if disclosure would constitute a clearly unwarranted invasion of personal privacy pursuant to the Freedom of Information Act. So it's a much more narrow, it says balancing public interest versus privacy interest. We can talk about what that balancing is a little bit later, but that's a significant change in the Access to Public Records Act. The other change, which I don't think is really going to affect anybody in Barrington, but the second change was to the pension substantive provision. The Access to Public Records Act used to say that pension records that were established by the general laws were public records, and there were some governmental pension records that were not established by the general laws. They were maintained by their government. They involved public funds, but they weren't established by the general laws. So what the General Assembly did last session was strike the requirement that it had to be established by the general laws. So all public pensions now, whether they're established by the general laws or otherwise, are public records. Those are the two substantive changes. As I said, there really weren't in quantity a lot of substantive changes, but at least that first exemption is a big exemption. It's the one that gets cited most often, so that is a significant change.
While Mike takes a sip, we have such good attendance tonight, we ran out of handouts. So for those of you who want a handout, Mary and Carol will be taking your name and email address as you leave tonight, and they will email the handouts to you.
And as I said, they're also on our website, www.riag.ri.gov. And that's the home page, the main page, and you can just click on the Open Government tab, and that has these handouts. It has a lot of other information also. But moving to the procedural provisions, which were heavily amended under this legislative session, all public bodies had to, under the previous legislation, had to have procedures regarding Access to Public Records Act. The legislature made it clear during this legislative session that these procedures had to be in writing. That's consistent with some AG findings that we've had in the past, that procedures had to be in writing, but now the General Assembly has codified that. And there are important reasons for that, why you have to have procedures and why they have to be in writing. There's one, your procedures can, talk about it in 1 second. The General Assembly added some language to kind of put some meat on the bones about what these procedures had to have. They had to be, these procedures had to identify either a person or a unit where the public could make public record requests. They also had to identify how to make a request and where to make a request. So these are all required now, and I talked to Andy earlier before this program tonight, and I guess in Barrington, all the requests, I already forgot, but all the requests go through the town manager, except for police records.
That's right.
Right. So that's the procedure here in Barrington, and the town manager has been designated, except for those police records, as the public record officer or unit. As I said, other than these requirements, the procedures are kind of open-ended. You can require a written request. There's an exception to that, and you can't require a written request for documents that are available under the Administrative Procedures Act, or for documents that are prepared for or readily available to the public. So just, you may want to take a look and make sure that the Barrington's policy doesn't say that all requests have to be in writing. We've said that that violates the Act because under the terms, the strict terms of the Act, there are 2 occasions where requests don't have to be in writing. As you see down here below, there's now a requirement to make sure that the public doesn't have to use a specific form to make a public record request. They can use any form. It doesn't have to be your town form, as long as what they're providing to you is identifiable as a public record request. A copy of the procedures have to be posted on your public body's website, if a website's maintained, and be made otherwise readily available to the public. And we had some cases where public record requests would be made to a public body for records that that entity didn't maintain, and instead of responding to the request, the public body would do nothing. Under this new law, we had found that those were violations, but under the new law, the General Assembly would codify that again, and even if you don't have the records, you have to indicate and respond within the 10 business days that that your public body does not maintain the records. So, Mike? Chief?
You mentioned earlier about the person making a request does not have to put it in writing or give the person's name or the reason. So, say they do that verbally to a records clerk. Now the clerk makes a copy, they want to give it back to this person, but we have a receipt that they received within that 10-day period. And they don't want to sign that receipt, so how do you handle that?
You know, I think a lot of this kind of just has to, I guess the legal term is wing it. I go into my boss to ask him a legal question, and he just says, well, go make it up. But I think that that's kind of the answer. You know, the Act, and we'll get to it in a couple minutes, there's a slide that says you can't require, you know, you mentioned that you can't ask somebody the reason or who they are or the reason for them making a request. That's not exactly what the Act says. The Act says, and again, looking at it strictly, and that's how we interpret it strictly, the Act says that you can't require a person, you can't require a person to provide their name or the reason they want the records as a condition to providing or fulfilling their record request. So I can't say to you, I'm not going to give you the records unless you tell me your name or your reason. To ask them what the, you know, I've had situations where people ask me for records requests and they're kind of all over the place and they don't know exactly what they're requesting, and I kind of just say to them, look, what is it that you're trying to get to? Let me see if I can get you there. That doesn't violate the Act. You know, your situation where they refuse to sign a receipt or something, I mean, I would probably just indicate refuse to sign. I mean, at the end of the day, what are you going to do? I mean, you can't put a pen in their hand and make them sign, so, you know, if they're going to walk away, I probably wouldn't get into the whole issue of, well, I'm not going to give you the records unless you sign for a receipt.
I would advise the same thing, just have the clerk indicate, you know, record handed over on such and such a date, refuse to sign. and have it signed, dated by the clerk at the time.
And depending on what the situation, I mean, we get into these factual scenarios, but depending on what the situation is, if it's a large public record request and you're charging for it, they may very well be giving you a check anyway. So, under the Act, the Chief mentioned 10 days. Once a public body gets a public record request, there must be a response within 10 business days. And that's really one of the real hallmarks of the Act, and it's something that at the Attorney General's office we're really keyed in on, making sure public bodies respond within 10 business days. Within that 10 business day period, you have to do one of three things: either provide the records, deny the records, or extend the time for good cause. And there's been a couple amendments with respect to providing the records and with respect to the extension for good cause. The General Assembly didn't really touch on what happens when records are denied within that 10 business day period. But for providing the records, it used to say here that before you provided the records, you had to provide an estimate of any cost that would be assessed to the person. They've changed that. Now it just says that upon request, an estimate has to be provided. And you see the others, which are pretty self-explanatory. Provide a detailed itemization upon request. The search and retrieval has to be done in a reasonable amount of time, and a waiver upon a court order. The procedures for good cause, again, the General Assembly put a little bit more meat on these bones. And if you're going to extend the time, it's an additional 20 business days for a total of 30 business days. That extension has to be done in the first 10 business days. So again, something has to happen within that 10 business day period. And that's really, unfortunately, where we see a lot of violations. For whatever reason, a public body won't do something within 10 business days. So if you leave with one thing here today, it's that when you get an access to public record request, something has to be done within that 10 business day period. Providing records, denying them, and then there's the procedures here for extending the time another 20 business days for good cause. The extension has to be in writing. It has to be specific to the request made, and it has to fall within one of these categories, either based upon the voluminous nature of the request, the number of requests pending, or the difficulty in searching, retrieving, or copying records. And again, that extension has to be done within 10 business days. We talked about earlier that there's a requirement under the new Access to Public Record Act that your procedures indicate who the person or unit is that handles access to public record requests. Apparently here in Barrington, it's the chief for police records and the town manager for all other records. But the unavailability of that designated public record officer is not good cause. So you can't extend the time based upon the absence of one of the designated public record officers. One of the big significant changes that the General Assembly made was the cost and delivery of documents. The Access to Public Records Act has always stated and continues to state that a public body can, doesn't have to, but a public body can charge 15 cents, a maximum 15 cents per page for copying documents, $15 per hour for search and retrieval with the first hour free, and the actual reasonable cost for providing electronic records. And what the General Assembly did last session is they provided this provision, which says that at the option of the person who's requesting the documents, the public body has to provide delivery of those documents, either by fax, by electronic means, or by mail, unless doing so would be unduly burdensome due to the volume of the records requested and the cost. So now any person who has a request made to them, they have the option to have it delivered at their, however they want it to be delivered. I said that there were a lot of cost provisions that were added. And here are some more. If a person makes the request for delivery, they are responsible for the actual charge for delivery, postage. I'm not sure that electronic or fax is going to be a charge, but at least with mail certainly. And if you have documents that are in storage, and if your public body is charged an actual retrieval fee to retrieve those documents, that retrieval fee gets passed on or can be passed on. If somebody's made multiple access to public record requests to your entity over a 30-day period, for purposes of calculating that search and retrieval cost, all of those requests are added as one. So I had indicated just a couple moments ago that if a public body is charging for search and retrieval, it's a maximum of $15 per hour with the first hour free. If a person has made multiple requests to that same entity, a person or an entity, over that 30-day period, just for purposes of calculating that search and retrieval time, all of those requests count as one. So it's 1 hour free, not an hour free for each one. And all fees under the Access to Public Records Act are waived if a public body fails to provide timely access to records. You see the white portion and then you see the yellow. The white is what had previously and still is the Access to Public Records Act, and the yellow is the amendment. The Access to Public Records Act has always stated that any reasonably severable portion of a document has to be provided. The yellow is that what was added this year is that if an entire document is exempt, there has to be some sort of affirmation or certification from the document that no severable portion of that document exists. So if somebody makes a request for a document and the entire document is exempt, let's just take a witness statement, for instance, and the entire document is exempt because it's an ongoing investigation, the disclosure of that document would hinder the investigation, affect somebody's right to a fair trial, then there has to be a certification or some statement in that denial letter that no portion of that document is reasonably severable based upon the exemption. And you see the D'Oliveria case here. And I think that I know this case involves law enforcement, the Department of Public Safety, but I think it's actually a good case for anybody, whether it's law enforcement or not. And D'Oliveria was the law firm of D'Oliveria and Morgan, I believe, or at least one of the law firms.